Good morning, good afternoon, and good evening to some.
Yeah.
So I would like to welcome everybody to IKAM panel discussion on Pakistan's federal Sharia court decision. Thank you for being with us and joining us. Taking this advantage of this occasion, so I would first say a few words about Research Center for Islamic Economics, IKAM, and what we are trying to accomplish with this talk before I hand over the floor to our respected panelists. Research Center for Islamic Economics, IKAM, was established in December 2016 with the purpose of providing a resource rich environment to academia and practitioners for research in Islamic economics and finance. The center aims to produce competent ideas and theories in order to build Islamic economic thought in a holistic manner. The center's main activities include various different academic and industrial studies, projects, education, training, and meetings to realize its goals. So we offer seminars, training and development programs. We conduct research projects, publish books. We have a publishing house called İKTİSAD Publishing House, and also we publish country reports and policy papers. So we also offer a platform for scholars, researchers through our Web of Science Index journal, Turkish Journal of Islamic Economics. Of course, we organize regular workshops, conferences, and symposiums. Especially our annual Islamic Economics Symposium have proved to be a milestone in the field of Islamic economics. This year, we are organizing the 9th one. So it goes back to nine years ago. The center, in a sense, functions as an information and proposal provider to all the stakeholders of the system, including the regulatory bodies, financial institutions, investors, entrepreneurs, and academia. So IKAM is trying to bring together through talk series a platform for discussion on issues that pertain to all of us. So today's topic is one of them, I think. So as you know, the Federal Sharia Court of Pakistan on 28th of April this year announced a verdict in a long pending case on interest, declaring the prevailing interest-based banking system as against the Sharia and directed the government to facilitate all loans under an interest-free system. So in its long-awaited verdict, the court ruled that the federal government and provincial governments must amend relevant laws and issue directives that the country's banking system should be free of interest by December 2027. Of course, we will listen the details from two panelists, but let me give a brief info about the case, and then I will give the floor to Professor Muhammed Eyüp. The first petition for the evolution of the interest-based banking system in the country was filed in the Federal Sharia Court on June 20 in 1990, I think. The then Chief Justice of Federal Sharia Court, Dr. Tanzil Rahman, had constituted a three-member bench that delivered judgment in the case on November 14 in 1991 and sought its implementation by April 20, 1992. The then Pakistan Muslim League Nawaz government had challenged the decision in the apex court. Years later, on December 23 in 1999, the Supreme Court upheld the decision of the Federal Sharia Court and directed authorities to ensure its implementation by June 30, 2000. Subsequently, a review appeal was filed in 2002 with the top court, and on June 24, 2002, the decision of the Sharia court was suspended, and the case was referred back to the Federal Sharia Court for interpretation of Riba. The case against the interest rate system had been pending in the Sharia court for the last 19 years. Around 9 Chief Justices of the Federal Sharia Court have completed their terms since then, but the case remained undecided until its verdict was announced on 28th of April 2022. I mean, we will listen our panelists, and our first panelist is Professor Muhammad Ayub. Professor Ayub, who is a juris counsel for rehiring of Riba case by the Federal Sharia Court of Pakistan since 2013. Professor Ayub is founder, editor of the Journal of Islamic Business and Management of Riba International University, Islamabad. And he served the State Bank of Pakistan as a central banker in research department, Islamic banking department, and the National Institute of Banking and Finance, the training arm of SBP for 28 years. He is master trainer in Islamic finance and an established educationist in the area of Islamic economics and finance. He is member of education board of IOFI, Bahrain, and the Chamber of the Curriculum Review Committee of IOFI. Professor Ayub also served as member of the Sharia board of the Bank of Khyber. Professor Ayub's unique contributions to Islamic finance include Islamic finance textbook, Understanding Islamic Finance, which was translated into Arabic, Turkish, Malay, Urdu, and other languages. And we translated his book in our publishing house, İktisat Yayınları, and it is one of the main textbook that we are using in Turkish universities and institutions. He also published several papers, articles to various journals, a number of chapters to edited books on Islamic economics and finance, and presented many research papers in international conferences on Islamic economics and finance. So I would like to turn over the floor or screen to Professor Ayub to talk about the long journey of the judgment. Welcome, Professor Ayub. The screen is yours.
Thank you, Prof. Rikmat, for your introduction and for inviting me to this webinar. Actually, Pakistan, like other countries, is doing a lot of efforts to introduce Islamic banking in Pakistan since last 50 years. But question is, what happened? Why this long journey of almost 40 years, in which 32 years actual proceedings in the courts? So basically, the main reason is that Constitution of Pakistan requires the state to transform the whole system from interest-based to the Islamic principles. This is the main reason. First, the belief, we almost 97% population in Pakistan are Muslims, and it means that the Quranic injunction requires us to eliminate riba, and then our Constitution of Islamic Republic of Pakistan, this makes a duty of the state to transform the whole economy. Or similarly, not only the Constitution 1973 as is now, the previous Constitution in 1956 and 62 also required this. So the main bone of contention had been that we are required, the state is required to eliminate, to remove all such laws who involve interest in any other manner. Otherwise, you know that Islamic banking has been pioneer in global move to Islamic finance, and the Council of Islamic Ideology, that is the constitutional body of Islamic Republic of Pakistan, they gave their first comprehensive report ever in this modern ages in 1980, and that included almost discussion on all areas of modern economy. And that required that Islamic, that the system, the whole financial economic system may be transformed to Islamic principle, but that could not be accomplished practically. So, ultimately what happened in 2002, the then government led by President Musharraf changed this policy to parallel function of the conventional and Islamic system. So this is the main reason that the case is now being taken up in the courts for last around 30 or 32 years. So first, just to introduce, as Prof. Nikur said, which are the institutions involved in this whole process. First, this is the Federal Shariat Court, this is equal to High Court, and then it's appellate bench of the Supreme Court of Pakistan. Basically, these two institutions, and the Sharia Court and appellate bench in the Supreme Court of Pakistan, was added to the Constitution of Pakistan in 8th Amendment in 1980s. So, accordingly, the State Bank of Pakistan and the Ministry of Finance and the Prime Minister, President, and Federal Cabinet all are duty bound to ensure that all laws in Islamic in the country are according to Quran and Sunnah. How this duty has been assigned to the government of Pakistan, and what is the journey? First of all, the father of nation, Muhammad Ali Jinnah, Qaid-e-Azam Muhammad Ali Jinnah, basically, when inaugurated the State Bank of Pakistan in 1948, he suggested the State Bank to evolve banking practices compatible with Islamic ideas of social and economic life. Similarly, the objective resolution of the Constitution of Pakistan that has been in all constitutions that required that the Muslims shall be unable to order their lives in individual as well as collective spheres in accordance with the teachings and requirements of Islam as set out in Quran and Sunnah. So, what is the constitutional requirement? The Constitution requires the state shall ensure the elimination of all forms of exploitation. So please consider not only riba or interest, all forms of exploitation have to be eliminated, and the gradual fulfillment of the fundamental principles from each according to his ability to and work. So Constitution of the country makes it part of the principles of policy. Basically, though, what are the principles that will have to be taken into account for this transformation? So there are 4 or 5 principles. One of them is to reduce disparity in the income and earnings, and then to eliminate riba as early as possible. The first one, E, it means I want to emphasize that when we are required to transform the system, we are required to realize an objective, and that is that there should not be concentration of resources in few hands. So there had been progress in Pakistan in 2 areas. One in non-interest-based banking system, NIB. This is the banking system that was introduced in Pakistan in 1980s, and then the other was the Zakat or Ushur Ordinance 1980s. It means those fiscal and monetary sides were taken up by the state. So what was that NIB system? Basically, at that time, there was the Pakistan Banking Council, parallel institution of the central bank. So the PBC was required to develop a document for banking system. They developed 32 documents, but the documents contained some problem, and the State Bank of Pakistan introduced 12 modes that were distributed to 3 categories, and categories, the trade-based financing and musharaka-based financing, and service-based financing. So these 12 modes also include the sale of debt and sale of receivable and buyback. This we call INA. So when the system was practiced in Pakistan, some people went to the Federal Shariat Court. By that time, the Federal Shariat Court, the bar that was put on the Federal Shariat Court in earlier part of 1980s was lifted, and the practices of NIB, non-interest-based banking system, was challenged in the court. At that time, the whole banking system was Islamized, I think. I want to clarify. But when the Federal Shariat Court took it up, so the judgment was that the system as adopted by the banks was not really Islamic, mainly because of the Baul-Ina, sale and buyback, and the sale of receivables and other such instruments. So in the meantime, there were other such institutions, as you will see. There was Sharia Ordinance 1988, and there was a number of Islamization commission, and all these commissions were basically constituted to help the state to Islamize the economy, as was required by the 1991 judgment of the Federal Shariat Court. So particularly, there were 2 commissions. One commission was the former governor of State Bank of Pakistan, Imtiaz Alam Hanafi, and its report was in 1992, and the other was Raja Zafarul Haq Commission. This was 1997. Both these reports are available with the State Bank of Pakistan, and their summary is available in the history of the State Bank of Pakistan that was written by the Deputy Governor, the then Deputy Governor, Mr. Ashraf Nanjua. So, what happened then? So, when the court decided on 14th November 1991, it was that the system based on Baul-Ina and sale of receivable and other such contracts was not really Islamic, so it should be changed, and the date given was the 30th June 92. But the government went into appeal, and the case remained with the Sharia appellate bench of the Supreme Court of Pakistan for 8 years till the Supreme Court gave its judgment. They rejected the appeal, and the judgment was upheld, or accordingly, the state was again required to transform the whole system by end of June 2001. But again, government went into appeal, and first they required extension that was given for 1 year, but then the government at that time basically reconstituted the Sharia appellate bench, and this was basically against the ruling court, but when did it, the newly constituted Sharia appellate bench basically reversed the whole judgment, and we call it review order. They remanded back both the judgment of the Federal Shariat Court and that of the Sharia appellate bench again, and asked again the Federal Shariat Court to rehear the whole case. This was basically a great setback to the institution. And then, keeping in view or in line with the recommendation of the judgment of the Federation of the Sharia Appellate Bench, a commission for transformation of financial system, CTFS, was formed in the State Bank of Pakistan. Very highly expert people were there. There were economists, there were the financial experts, there were Sharia experts. They gave their report, and their features of their report are also available in the history of this State Bank by M. Ashraf Janjua. So in the meantime, the Commission for Transformation decided to discuss the matter with the IMF, and accordingly, the two experts from the IMF visited Karachi, visited Pakistan, and these were the issues that discussed with them: the viability of the Islamic system, effect on resource mobilization, tools for monetary management, and supervisory and regulatory needs of the new system. It is good to note that both these experts, I know, I remember name of one of them. One was Ghiyas Shamsir. Still he is there in the IMF, and I forgot the name of the other. They recommended that the system is viable, and there is no apparent reason to believe that the system per se would generate adverse effects on savings and resource mobilization. Of course, they emphasized the need to review and revamp the supervisory and monetary system. And all these details are also available in the history of the State Bank. So then there was the policy change, and policy change was simply because the most difficult problem for the state was to transform the public debt system, how to fulfill the fiscal needs of the government, and what should be the alternative of the public debt. So this was the main reason, and there was a meeting in October 2002, a very high level meeting. They decided that now the system will not be transformed totally, and it could be in a future after some time, but for the time being there would be both system functioning. There would be full-fledged Islamic banks, there would be subsidiaries of conventional banks, and there would be standalone Islamic system of the conventional banks. Accordingly, currently in Pakistan, there are 5 Islamic banks are subsidiaries, and 17 conventional banks have their Islamic banking windows. And at that time, the Ministry of Finance and the government submitted an affidavit before the Sharia Appellate Bench that they were unable to transform the public debt. Basically, this was the affidavit that basically become the basis for the remand of this whole case, because the government has declared that they are unable to do this, otherwise the system could collapse. So the case was remanded in 2002, but no hearing could be made till 2013, and then it started in 2013, and from 2030 to 2020, they heard the case for about 10 years. And what is the product is before you and me. We all know. And now I will give very briefly its some points, and other implication will be discussing Professor Tahir Monsoori Saab. So main 2 points were about the government, the council, government lawyers were saying. One, they pleaded that the Federal Shariat Court might not be having jurisdiction to hear the case, because it also involves some such parts that are part of the Constitution. So the other main point was that they pleaded that Riba, the definition of Riba might not be clear, and they were of the view that the interest of modern day economy might not be that Riba that was prohibited in the Quran and Sunnah, because this was just a argument for argument. the court in its judgment court that it was dichotomic. The State Bank and the Ministry of Finance themselves are doing Islamic banking. When they are doing Islamic banking, it means that they are believing that interest is riba. Then what happened? So it was just a case argument for argument. So a questionnaire was distributed by the Federal State Court that included 14 questions. Some of those questions are also belong to the current practice of Islamic banking, but practically the FSC judgment discussed only the points raised in the review order, and it did not discuss in detail some points that was raised in by some people about the current Islamic banking. So basically, the court discussed the views of some Arab scholars and came to the conclusion that their views are might be basically apprehension expressed by those scholars, and ultimately it was concluded that as in the whole world we are trying to transform the system, so there could be no just also discuss about Fazal, but here it was issue that when they discussed exchange, simultaneous or hand-to-hand exchange of ribawi commodity like edible goods, and they did not specifically indicate the need for hand-to-hand exchange of monetary unit and currencies. I expect that Prof. Monsoori will discuss this issue. This is a very important issue that so far has not been discussed by the court. So the judgment also discussed the status of Islamic banking in the world, and in Pakistan advised that the international commitments are binding, and they also indicated the Islamic Development Bank and World Bank have also jointly done many works to finance infrastructure projects in Muslim countries, and then they also discussed some views of the IMF expert, and then what could be the role of Sukuk, and then the standards issued by the IOFI and IFSB. They also discussed this to prove that Islamic banking is now at a much higher stage, visible in the world, and it means that the definition of riba was no matter at all. Now we should give all our attention to introduction of Islamic banking. So salient point was actually these: all prevailing interest, commercial interest is riba. For future, government is directed to adopt standard Sharia modes that while borrowing either from domestic or foreign, fulfilling the commitment made so far. And then they observed that some changes have already been made in the State Bank of Pakistan Act and the Banking Companies Ordinance Act, so there should be no problem. And similarly, the Section 25, there is enable section of enabling section of all law empower the State Bank of Pakistan to introduce interest-free banking in Pakistan without any delay. It means that some changes have already made, and these changes are made during 1980s, so it should not be much difficult for the state now. So the judgment also indicated the possible modes that could be used for infrastructure development and development projects, and even this CPEC and all these things. Commodity, for commercial financing, they also indicated murabaha and commodity murabaha. So some modes also suggested to convert the public debt. So now how to do all this, and they believed that there has to be a gradualism, cannot be done overnight. So they suggested basically 3 dates. So these dates are the 1st June 2020. It means only 15 days now from now. By 1st June, all laws involving interest will cease to have effect. Very, very important. What will happen after that? Prof. Monsoori will tell us. Then by 31st December of this year, there will be basically complete legislation and amendments to so that the repealed laws that might be working. So by 31st December, the state will introduce new laws that would be used by the financial institution. And finally, the end of December 2027. It means that after 5 years, there will be complete transformation of the whole economy. It means not only banking system, but also in financial market, but other sectors of the economy. As I said, the requirement of the constitution that there should be no exploitation and all these things. So now the issue is that according to the constitutional provision, the appeal could be made before the Sharia appellate bench of the Supreme Court of Pakistan within 2 months by any private party and within 6 months by the government. Now the issue is that constitution provides, as you see this in red color, that no decision to repeal any law shall be deemed to take effect before the expiration of the period within which an appeal may be preferred to the Supreme Court, and in case appeal is preferred, before the disposal of such appeal. Now here is contradiction. The judgment says that some laws that involve interest will not be effective after 1st June, but now the article says that they cannot be repealed before expiry of the appeal period. So what would be its implication and what would happen? I hope Prof. Monsoori will tell us. And this is all. I think I tried to summarize what was this whole journey and what are the main salient features of this judgment. Okay, thank you.
Thank you, Professor Ayub, for your inspiring talk. So, I mean, we can get questions now, but it's better to listen our second speaker panelist, Professor Muhammad Tahir Monsoori, because he will give an overview about the feature of this issue and what will happen now. So it's better to listen to him and then get the question. So let me briefly introduce Professor Muhammad Tahir Monsoori. He is the former Vice President, Higher Studies and Dean Faculty at the International Islamic University, Islamabad. He authored over 12 books and 50 research papers on different topics of Islamic law and economics. Currently, he's associated with an Askari Islamic Bank as resident Sharia board member. He's also member of Sharia Board of Securities and Exchange Commission of Pakistan. So as I mentioned, he will talk about the issues related to implementation of this verdict. And so the screen is yours, Professor Monsoori. We can't hear you. 1 second. Yes, I think.
Assalamu alaikum wa rahmatullahi wa barakatuh. Dear brothers, I thank Professor Nekmetin, IKMA Istanbul University for giving me opportunity to share my views on the recent judgment of Federal Shariat Court. I will discuss some implications of this judgment for financial system and especially for the banking. We welcome and compliment this judgment, and we hope that this judgment will contribute towards the implementation of a fair, just, value-oriented Islamic economic system in the country as desired by the Federal Shariat Court in its judgment para 155, which I will tell you that what is that para. Professor Muhammad Ayub, he has mentioned that Federal Shariat Court has fixed 1st June as a day or as a date when all the anti-Islamic or Sharia non-compliant or Riba bearing financial laws will cease to have effect. And the second date is 31st December 2022, which means that by the end of this year, the substitute legislation has to be made. And all the contested laws should be brought in conformity with the teachings of Sharia. So these are two dates, and Professor Ayub has rightly indicated or mentioned that these two dates have created confusion. The reason is that the Constitution gives right of appeal for the government for 6 months, and within 6 months you can file appeal. Whereas you want from the government that it should abruptly convert all the system and change all these laws. And it means that 2022, according to this judgment, it means that the companies audit, which is the basic law, state basic laws are to be, they will be stopped and they will have no effect. And at the same time, there would not be any substitute legislation. Does it mean there would be no law for a period of 6 and 7 months? And it means that if State Bank want to function, to work, to monetary tools or other its functions, banking companies, they want to function, to do business, does it mean that they will not be able to do anything? Everything will be freezed. So this is the vacuum, and these two dates have created confusion. And to me, as Professor Ayub has mentioned, to me, this is unconstitutional. Unconstitutional in the sense that these laws should cease to have effect on 1st January 2023. And it means that when the appeal period is over from that date, but now you are giving for the appeal only 33 days. And out of 33 days, already 15 or 20 days have passed. So what would be, what would be the strategy? In the absence of any applicable law, how will State Bank will function? How will State Bank work? How will the banking companies, they will work? So there are many issues which need to be clarified or which need to be addressed. Now I come to the implications. To me, what appears to me is that as the judgment says that after 1st June 2022, contested financial laws will cease to have effect. It would mean that its implication would be that after 1st June, the banks, conventional banks, will not be allowed to receive any interest-based deposit. The banks, conventional banks, will not be allowed to advance any loan or give any financing facility on the basis of interest, because the thing is that there would be no applicable law in applying to it. In the same way, the implication is that the government, the State Bank of Pakistan will not be allowed to issue T-bills, federal investment bonds, provincial investment bonds, defense certificates, national saving certificates. The companies will not be allowed to issue, to raise their funds on the basis of preference shares, commercial papers, all these things. And what I am saying that when you have abrogated all these laws, it would mean that the banking companies and the other companies, they will not be allowed to deal in interest in any manner. So this is the thing, but I think that this will not happen. This will not happen because there should be some applicable law, and there would not be any applicable law. So this is the thing which needs to be addressed by the Federal Shariat Court itself. That what would be the strategy in the absence of any applicable law? Does it mean that conventional banks would abruptly convert to Islamic banking, Islamic modes on 1st June? It means that 100%, it would be 100% conversion. I don't think that this will happen. Another thing, and this is very surprising that Federal Shariat Court has dealt with some financial laws, but it has ignored many important, substantial financial laws which are equally repugnant to the Quran and Sunnah. I mean, for example, the Securities Act, the Futures Act. Securities Act clearly tells that the companies, they can raise their funds through commercial paper, through the issuance of preference stocks, all these things. And if in the same way, the Futures Act, and it talks about the currency futures, swaps, options, all these things. And so I surprised that if riba is prohibited, in the same way, qimar, maisir, gambling, futures, speculation, it is also prohibited. I mean, why Federal Shariat Court has not touched upon these laws, which are equally important? And it means that you will eliminate interest from the banks, from the banking sector, but it means that the interest will continue in other sectors, especially in the stock market and in other sectors. So I am saying that to free the economy from interest is important, but it is equally important to free the economy from maisir, from gambling, from speculation, and other Sharia prohibited. Many laws which were required to be dealt with by the Federal Shariat Court has not addressed those laws, and it is also necessary. Another point, which is also significant, many people know that the leading Islamic banks in Pakistan, they have their subsidiaries, they have their asset management companies, they have their mutual funds. And these asset management companies, I mean, they are also dealing in riba. And for example, Professor Yusuf knows very well that the Sharia screening criteria given by these Islamic banks as investment banks is that a company which borrows, whose borrowing is 37% of the market capitalization on interest. And if a company raises loan up to 30%, and 30% interest-bearing loan is permissible. In other words, they are saying that a company would be considered Sharia compliant if its interest-based borrowing is up to 30% of the total asset or market capitalization. What does it mean? And it means that if your free float shares, its total value is 1 lakh rupees, yani 100,000 rupees. It means that up to 37,000 rupees you can raise from the conventional banks on the basis of interest. In the same way, 33% lending, and it means that if a company lends on interest basis or places its funds on interest in interest-based schemes, in treasury bills, all these things, the company would be Sharia compliant if its interest-based lending is up to 33%. But if its lending exceeds and it becomes 34%, it would become Sharia non-compliant. I mean, it's surprising. This is surprising that a company is Sharia compliant, and you are allowed to invest invest in it, to subscribe its shares if its interest-based borrowing is up to 37%, and its lending is up to 33%. So I am saying that Federal Shariat Court should have addressed these issues as well, and it means that not only the explicit riba, but the disguised riba should also, it should have been. And what is the sense in it? International Fiqh Academy has categorically has declared that if a company is engaged in riba-based borrowing or riba-based lending, even if it is 1%, it is a Sharia non-compliant. But we are saying no, it is a Sharia compliant, and we give many reasons for this. So these laws and these regulations should also be addressed. Another thing is, and I was saying that why we need, why the laws relating to capital market, why we need that these laws should also be addressed. The reason is that Islamic Bank, they use stock exchange, they use mercantile exchange for their liquidity management purposes as well. Professor Ayub Saab knows very well that this Pakistan, this mercantile exchange, which deals basically in futures, its platform has been used by Islamic banks for commodity murabaha, and a fictitious commodity murabaha. Fictitious commodity murabaha means that in 2018, billions of rupees, they were transferred from one bank to another bank, from Islamic bank to conventional bank through commodity murabaha. I gave you one brief example that, for example, one bank, bank A has excess liquidity, and bank B needs the liquidity. So what you do is that you ask the HESCOL, which is a oil marketing company. So Islamic Bank will buy oil worth 10 million on cash, and then immediately it will sell. This Islamic Bank A will sell this oil for 11 million on credit of, say, 6 months or 1 year. And then Bank B will sell this oil again to HESCOL for 10 million. And it means that, and whole this transaction took place in hardly in 10 minutes. 10 to 15 minutes. It means that one point you will say that now this HESCOL has sold oil worth 10 million for to Islamic Bank A. Then the Islamic Bank A has sold to next 2-3 minutes to Bank B. Bank B again to. So I am saying that what is it? The ownership, the possession, neither Bank A is in need of petrol or diesel, nor Bank B is in need of petrol. Only this is just a lending. This is just a lending. And it means that Bank A Islamic has lent 10 million rupees to Bank B for 11 million. For a period of one. After the completion of this cycle, in other two banks will come and on the same tanker or the reservoir, that they will say, okay, you sell us, and in this way. So I'm saying that the Federal Shariat Court should not have addressed the explicit riba. It should have billions of rupees are shifting from Islamic banks to conventional banks. And why? The reason through commodity murava or something like. The reason is that they give a higher rate, and practically there is no generation of real economic activity. Practically there is no buying, selling, no liability. You take any risks. So what I say that the Federal Shariat Court, I mean, if there is an abrupt transformation from riba, from conventional banking, conventional financial system to Islamic financial system, I think that these Hila-based or these subterfuges-based products, they will gain currency and they will become the rule of thumb, and no one will question afterwards. So I think that a review petition should be filed with Federal Shariat Court, in which certain clarity should be sought from it, and all the objectionable, contested products should be brought before the. Now, what Federal Shariat Court has done? Federal Shariat Court says that we did not find any evidence proving that this is a Hila-based Islamic banking, because State Bank says that these are the Sharia approved, these are the approved products. I say that, have you investigated, have you examined, have you evaluated on your own these controversial products? There are many controversial products. Another thing is, which is equally important, and to which Professor Yusuf has mentioned, the thing is that we do not want that the financial system should conform to Islamic law in its form. It should conform to Sharia in its spirit as well. It means that we need an economic system which is which promotes or which ensures circulation of wealth, discouragement of concentration of wealth, equitable distribution of wealth, and sharing, risk sharing, real risk sharing, and fair distribution of real returns of the business. So, and that there should not be any exploitation. So I expect that the substitute legislation would take into consideration these goals. If these goals, these higher purposes of the Sharia, these Islamic, these goals of Islamic economics, if these are not taken into consideration in the substitute legislation, then the result would be that one exploitative system would replace another exploitative system. Because if this system is not contributing in, and it is not enhancing the well-being of the society, if it is not eliminating the concentration of the wealth, if it is not eliminating the exploitation, so it would mean that you are violating the spirit of the Sharia and the spirit of the Islamic economic system. So I am saying that this is a golden opportunity. While making substitute legislation, the legislation should be geared towards realization of certain higher purposes of the Sharia relating to economic system. And otherwise, this would be just otherwise it would be a futile exercise. And it would mean that you are saying that just change the contract mechanics. The validity of a contract, or the form, focus on the form of a contract is not significant. The thing is that the spirit of the Sharia should be observed in all the transactions. So I think that this is a time that the some jurisconsults, some Sharia scholars, they should file review petition with the Federal Shariat Court, not for the suspension of this judgment, no, for certain clarifications, so that if the system is converted to an Islamic financial system or Islamic economic system, then it should be a real value-oriented Islamic economic system. Otherwise, otherwise all the efforts they will be counterproductive. So this is my humble submission.
Okay. Thank you very much, Professor Tahir Monsoori, for your also inspiring talk. Actually, Professor Muhammad Ayub gave the long journey of this judgment, and you mentioned some issues related to implementation of this verdict. Thank you very much. So we have now many scholars, experts, colleagues, and I'm sure there are so many questions. So it is no Q&A session. So if you want to ask a question, please raise your hand and ask your question to, or any comments, any ideas. Okay, Professor Mabid Al-Jah is here, and so could you please open his voice, his micro? 1 second. Sorry.
Thank you very much, Mr. Chairman. First of all, I'd like to start quickly by saying the honor of attending the court session that was in the 90s with the delegation of the Islamic Bank. And second, we really, it's unfortunate that Pakistan, or the Islamization or Islamic economics, has been introduced to Pakistan with two mistakes, which have to be remedied as quickly as possible. The first mistake is that there is this confusion between Islamic economics and Islamic finance. They are not the same. Islamic finance is only a part of Islamic economics. If Pakistan wishes to apply an Islamic economic system, particularly a monetary and financial system, it must have a structure, a model. Now, this model was published in 1980 in an article which was published by the International Center for Islamic Economics in King Abdulaziz University. I have been the author of that article, and the system here envisages a switch from debt-based money, because debt-based money is the source of all debt-based processes which corrupt an economic system. So we must remove this based money and use equity-based money. The second thing is that we would like to give the central bank an absolute monopoly on issuing money. Why? Because we would like to get all the seigniorage to society, not to banks. And this has been recommended by the IMF when they have reviewed the Cambridge plan for reform that was declared in 1930. Also, that the benefits of the switching to an Islamic monetary and financial structure the benefits are great, and they have not been spelled out to the Pakistani authorities. In other words, you see, once you have the ability, or once you switch to equity-based money, you will issue all money in the form of central bank investment accounts with all banks, conventional and Islamic. Of course, conventional banks can decline if they wish. We can give them some kind of a transitory period or something like that. But this money would be available only for financing according to Islamic finance rules. The central bank would issue a handbook of Islamic financial products, a short one. We have the handbook already in Arabic and English, and we can make it available from Turkey to any Islamic country. These requirements of switching from debt-based to equity-based money, from also constructing an Islamic equity-based money market, where the tools would not be government debt, but the tools would be certificates issued by the central bank, whose value would be placed on mudaraba basis with banks, and this would be tradable. And the price of, or the rate of return, the price of these certificates would set the rate of return, like the rules of any monetary and capital market. And the rate of return on these certificates would be directly connected to the rate of growth, so that the central bank would use the rate of growth in the economy as an anchor to monetary policy. So we would have absolute price stability, and our currencies would stop deteriorating in the market. Our terms of trade would stop getting worse and worse over time. So we really want to switch from the microeconomic approach that we have taken since the first meeting of the appellate court in the 90s to the macroeconomic approach. And we must supply the Central Bank of Pakistan a detailed Islamic monetary and financial structure based on that article that I mentioned to you. Of course, we can start with the monetary survey, that the latest one issued by the central bank, and we show them what happens in terms of how equity-based money would replace debt-based money, how the seniorage would be collected from profits earned on the investment accounts of the central bank, how monetary policy can be conducted through open market operations in the central bank deposit certificates that is traded in a money market. This is what we need. And also, we would like to stop the competition between the court and the central bank. Yes, the court can issue laws and so on. I really am not an expert in the legal traditions of Pakistan, and I know that this must be handled with due respect and due appreciation. But I do not want the court to become a regulator of Islamic finance or of the financial and monetary structure. And I don't want to all resist this change, and also to look for some hazy and uncredible opinions imported from Egypt that riba is halal or something like this. Is ridiculous. Those, of course, I'm an Egyptian. So do not misunderstand me. But I'm saying are Sultan scholars, the scholars of Sultan. And since the government of Egypt likes Riba, they like Riba too. And الناس على دين ملوكهم. People follow the religion of their leaders. And unfortunately, we have the wrong leaders with the wrong religions. So that's the idea. So please, now what do? Let's be practical. First of all, I would request the chairman, as also being one of the officials of IKAM, the Turkish Association of Islamic Economics, to handle, first of all, to work with me. I am volunteering to give a scenario to Pakistan to the switch from the current conventional macroeconomic model to an equity-based macroeconomic model, and to not to worry about Islamic finance. Islamic finance will be controlled by the central bank according to rules issued by it. We will give the central bank the raw material, the handbook, to issue it in any language and any style it wants. This would be the key. Now, let me just give you one concluding remark here. That's how much is the seigniorage, can we call it? In the case of Turkey, the scenario that I have structured for Turkey, based on the latest monetary survey, it is more than 3 or 4 times of government tax and non-tax revenue in the budget. Now, this is a huge source of income. It can be used to relieve Pakistanis from taxation, particularly sales tax and then income tax, maybe restrict income tax to higher brackets or the highest brackets. And also it can be used to develop a Pakistani infrastructure, up-to-date infrastructure, so that Pakistan would grow, because growth is directly related to how modern and how sophisticated the infrastructure is. This is what I have, and of course, I thank you, Mr. Chairman, for giving me the chance. Thank you very much.
Thank you, Professor Jarhi. So for your actually comments and advice. So I think about it to discuss this issue in detail and get some like advice from experts, from practitioners, and from academics like yourself. Thank you very much. So do you want to, I mean, there is no question. It was basically some comments. So let's, Miss Saba Kerimi. Sure. So she wants to ask a question. Yes. Okay, go ahead.
I'm an Islamic University graduate where Professor Monsoori used to teach. I have I would just like to follow up on the comment that Ustaz Mahbad made about Ulama Sultan. In Pakistan, we have Ulama al-Bunuk, or I don't know if my Arabic is not that good, but Ulama al-Masrafi. And I think Dr. Tahir Monsoori knows this issue really well. There's a whole politics behind this judgment. There are ulama who benefit directly from some of these Islamic banks. We're going to benefit from this judgment.
Will you please raise your voice?
Yes, I can't hear you.
Yes, please raise your voice.
Oh, you can't hear it? Okay.
Yes, yes. Yes, continue, madam, continue.
We can't hear you.
Is it better?
No.
Hey, can you hear me?
Yes, now it is
Okay.
clear, yes.
Let me just stop my video. Okay. So my question was about the ulama of the banks. The ulama of the bunuk. And so there are judges who were directly involved with the previous judgment who benefit directly from these banks, and they have a huge role to play with Islamic finance in general. And they also have a lot of grassroots support in Pakistan. And so my question is, if this judgment goes on appeal, do you expect resistance from those very ulama who are getting money from these Islamic banks, and now their children are getting money from these Islamic banks, and they're acting as jurisconsults in a lot of these cases? So yeah, that's my question.
Question to whom?
It's primarily for Dr. Tahir Monsoori.
Okay.
Actually, I tell you that in 2018, we tried to change the Sharia share screening criteria and to tighten it. Instead of 37% interest-based borrowing, to reduce it to 30% or something like that. But unfortunately, the resistance came not from the bankers. The resistance came from the ulama. I mean, up till now, I mean, in 2018, Securities and Exchange Commission of Pakistan issued Sharia governance regulation, in which they said that a company, if its borrowing exceeds 30%, if its lending, interest-based lending exceeds 30%, then it would be Sharia non-compliant. We couldn't tighten the criteria. We couldn't implement it. The whole resistance came from the ulama. And this is another thing is that one alim, he sits on the board of the bank, and he sits on the central on the board of Central Sharia Board. And it is surprising that you approve a product as a resident Sharia board member or as a Sharia advisor of a bank, and then you are on the central board as well, and then you vet it. Obviously, this is a clear clash of interest. Dr. Ghazi, madam knows that Dr. Ghazi, he was our vice president, he was president, and he was also chairman Central Sharia Board of State Bank of Pakistan. He said that in 2006, this commodity murabaha product was brought to us by one Sharia advisor who was a Sharia advisor of a leading bank. And he was himself a member of the Central Sharia Board. Now, this is clearly, I mean, what is conflict of interest? Conflict of interest means that two such positions which affect your objective judgment. Here, I mean, you are on the law of Bank Negara, perhaps you know, it prohibits any board of Central Sharia Board, prohibits him from working in any bank. Unfortunately, this is in Pakistan, that you are in a bank and then you are on the board of Central Sharia Board as well. And then how can you, obviously, the product that you have approved in your bank, obviously you will support it, you will emphasize it. So there are many cases. We try to put capping on their working. And if, for example, that a Sharia advisor should not work in more than 3 banks. There was a hue and cry. There was a protest from all the Sharia advisors. We said that humanly, it is not possible that you work in 20, 30 banks. It is not possible because you have only 24 hours. In 24 hours, obviously, sometimes you have to, for eating, for sleeping, something like, how is it possible? But it is surprising that these Sharia advisors, they are able to do, for 20, 30 banks with all clash of interest. So I'm saying that is why Islamic finance is losing its credibility, its Sharia legitimacy. The people do not trust. The people do not trust. They say that this is just a change of brand. This is just a change of name. I am saying that as long as Islamic finance is not directed towards the achievement of higher Sharia purposes, which is the circulation of wealth, discouragement of concentration of wealth, fair returns, distribution of fair returns of business, I don't think that this this qualifies to be called or categorized as Islamic banking or Islamic finance. No, this is not Islamic banking. This is just call it, this is riba free banking, bas, full stop, not more than that.
Okay, thank you, Professor Monsoori. Now we had Dawood Hamza. He raised his hand. Could you please ask your question? Here, if not here, Mustafa Abu Bakr also raised his hand.
Assalamu alaikum.
Wa alaikum assalam wa rahmatullahi wa
barakatuh. Mustafa Abubakar from Nigeria. My only request is to please request Professor Kabir Hassan, who is here in attendance, to say some few words here. Did you hear me?
No, we can't hear you clearly.
Okay, I said I have stated in the chat box
Okay.
that I request you to ask Professor Kabir Hassan to say some few words.
Okay, I'll ask him. Okay, we have Munib Hussein Gato, he raised his hand. Yes, Dr. Munib.
Hello, are you able to hear me?
Yes.
Yes. Yes.
Thank you, Professor Najmuddin, for organizing this very important discussion. My question would be to both of the panelists, Professor Tahir and Professor Ayub. And the question would be, let's suppose, hypothetically, supposing that maybe in 5 years' time, we are implementing not only the outlook of, Islamic banking and finance, but Islamic banking and finance is basically implemented in its essence as well. Hypothetically, in 5 years, we are able to, do the homework, what's expected from us, and Islamic banking and finance is implemented in Pakistan in its essence as well. So I just want to know that has the homework been done on what would be its international ramifications on Pakistan in terms of maybe certain power corridors may not appreciate the fact that Islamic banking and finance, Islamic economic model is being implemented. So how has there any thought process gone into this thing that how do we manage the international aspect of this thing? Assuming that we are able to undo the hurdles that are there in terms of implementing it locally first, but at the same time, we also need to be sure of how do we handle it in terms of its international ramifications. That would be my short and precise question. Thank you.
Thanks. Professor Abe, you go first.
Bismillahirrahmanirrahim. Actually, as I indicated briefly in my presentation, the court has indicated the modes and the procedures that could be adopted for infrastructure financing and for project financing and all those financing that are related to real sector business and production and other processes. But the issue regarding the debt replacement is really very important for us or for any other country. And as I indicated in the very beginning, that this was the issue that this discussion on the definition of riba was generated. Otherwise, if all in other countries both systems are operating simultaneously, we could do this. But as our system, as our constitution requires, so now it becomes duty of the court. Now, court has indicated that first, all those activities that are related to real sector activity, like project financing, like syndicate financing, it could be possible through istisna, through ijara sukuk, and through many other things. But you are right, these are the very important issue. And of course, the court has given the verdict that after December 2027, all financing from within the country or from abroad should be on interest-free basis. Now, what would happen? The court says that it is basically job of the parliament and job of the institution like the central bank and the SCCP and the planning commission and the economic affairs division. These are basically custodians of the economy and custodians of the monetary and fiscal system. They are required to do all these things. But really the problem is particularly in respect of public debt system. Here, one particular government is raising T-bill, and T-bill involves a fixed rate as suggested by the commercial bank themselves. The state bank calls bids, and the private banks, they give bid, and is in this way the government raises debt from the banking system. So, what could be its alternative? One alternative is that for the time being, we go for any rate that could be related to GNP growth rate, GDP growth rate, and in 1980s, early 1980s, this alternative was suggested or indicated by the panel of bankers and economists that was constituted by the Council of Islamic Ideology in Pakistan. But the council at that time did not agree to this. Simply because the partnership mean musharaka and mudarba mean sharing in actual profit and end result of any economic activity. But now we have seen down the line after 40 years, we see that many products as being used by banks all over the world, and particularly in Pakistan, are such that there is change, as Professor Monsoori is saying, there's simply there's a change, that could be a legal change, a form. And it's best example in the running musharaka. You might have listened this product in Pakistan. Now it is used almost, it reflects 25% of the investment portfolio of Islamic banks in Pakistan. But unfortunately, the result charged by Islamic banks in running musharaka is 100% fixed, in the sense that there is a two-stage profit sharing ratio. And in the first stage, banks get their target profit that is related to the Kaiver or any other benchmark. And in the second stage, almost all income, all excess profit over the target profit goes to the company and the client. So if this is permissible, at least legally, so I think that they also should allow any kind of T-bills that are related to the GNP growth rate or GADP growth rate or any other. I think Prof. Mawad will could explain this if I think he is, mashallah, he knows all these things. So the similar things could be for abroad also. So the real the solution is that any nation, because should become sufficient, it should be producing thing, it should be exporting, not importing. But unfortunately, we have become an importing country. Our deficit, current account deficit, is increasing day by day. So your question is really very genuine question, and we have to consider this. But what I can tell you is that the court has given the verdict that after December 2027, all financing from within the country and from abroad has to be Sharia compliant. And court says that it is not our act, what we say, duty to suggest all these things. It's a duty of basically the central bank of the country and other, the Ministry of Finance and Planning Commission and the other experts in economics and finance. So I think what I could explain, and if Prof. Monsoori might like to add.
Actually, if you allow me, only one point I want to make. Professor Ayub Saab, he has discussed about the foreign debts and how, I mean, the foreign commitments, yeah, all these things, and how can we, in what mode can be adopted for it, and he has indicated some modes. The question was that, are we ready to implement Islamic finance in its real essence, in substance? Have we made preparation for that? How would the scholars respond to it, or in all these things? I think that this is the responsibility of regulator, State Bank of Pakistan. The State Bank of Pakistan, because now, again, what is happening? Now what is happening is that our 80% financing goes to corporate sector, to blue chip, big companies. It means that the beneficiaries, so this is against the financial inclusion. It means that the general public, common person, he is not benefiting from the Islamic financial system or from the Islamic banking. Now, the State Bank of Pakistan should regulate this issue, the issue of concentration of wealth. And what I'm saying that there is a very quick and rapid transfer of wealth from the depositors, common person, to the corporate sector. I mean, they are the real beneficiaries, and this system is causing and promoting the concentration of wealth in few hands. The State Bank should monitor all this thing, and for example, they should see that if the financing to corporate sector is now 80%, they would say they no. You raise financing for SMEs, you raise financing for agriculture sector, you raise financing for which would aid to the financial inclusion. That financing facility would be available at affordable rates to other segments of the society as well. What I'm saying, that currently Islamic banks, they give, they allocate hardly 1% of their financing to SME, to agriculture, all to these groups. And while we need that agriculture should be promoted, on the other hand, we find that, I mean, through running Musharaka, to which Professor Ayub Saab was indicating, which is a replication of running finance. Fixed rate. I mean, you are giving fixed rate to him, all this thing. Concentration of wealth, Yani running musharaka is violating the principle of circulation of wealth. Running musharaka is violating the principle of fair distribution of returns among the parties. And what is the logic? I mean, what right the bank has, I mean, to give 20, yani say, if the real profit is 3 million, 4 million, 30 million, 40 million, I mean, you give as gift to the corporate client who is already benefiting from it, and just you get 5% or 6% on your, and if we go through the old previous judgment of Federal Shariat Court 91, as well as the judgment of Supreme Court Sharia Appellate Bench, the whole focus of this judgment is on profit and loss sharing, on real distribution of returns of the business. Here, I mean, you have totally violated the spirit of musharaka. This is not a musharaka. Here you are giving a fixed return to the, I mean, the bank is charging a fixed return in as it is on its overdraft or facility or something like that. So I'm saying that this should be done by the State Bank of Pakistan in collaboration with the ulama, with the Sharia advisor, with the Central Sharia Board. Now, what happens that the banks say that you, Sharia advisor, you have no role in our business decisions. I mean, if we, I mean, the concentration of wealth, non-concentration, this is none of your business. You just give decision whether this transaction is valid Islamically or not. Now I'm saying that even the issue of validity, invalidity is also controversial. I'm saying that the Islamic banks in Pakistan should at least adopt AOFE standards as benchmark. But in Pakistan, there is a violation of AOFE by 20 and 30% in many cases. So I am saying that it means that you want that Sharia, which you think it is a Sharia, not the Sharia, which is through collective ijtihad or which is a centralized interpretative authority. And we say that AOFE is a centralized interpretative authority. If they have issued a standard, we should comply with it without questioning it. It's unless it is clearly in violation with the Sharia. But I am saying that now the currency salam, all these things, what is the logic in it? You say that this modern paper currency is not a legal tender. This is a fulus, copper coins. And on copper coins, the rules of Riba do not apply. So futures, all these things. So briefly, I would say that this needs that all the controversial products have to be revisited, and not by the scholars associated with the banks, because they are the beneficiaries. Other scholars should contribute in it, so that the Islamic finance should be a real Islamic finance.
Okay, I mean, I know it is midnight, maybe the very early morning in some countries. So we are running out of the time. I'll get last two questions, Dr. Halza Nova and Shahzad Ahmed, and then close the session. We have excellent discussion, but it seems that we need more discussion, maybe like some workshop on this issue. So I'll get last two questions, Dr. Halza Nova and Shahzad Ahmed. Yes.
Okay. Thank you very much, Professor Metin as moderators and all Professor Paul, the speakers. Thank you very much for the opportunity given ask questions. I want to ask that do the courts in Pakistan also recognize the division of foreign courts or arbitration regarding cross-border Sharia economic disputes? If yes, and what are the terms and procedures for foreign courts or arbitration awards in Pakistan? Because in some cases, there is decision cannot be implemented in their country because contrary with their law national the country. That's all. Thank you. Dr. Professor
I'm
McLean.
sorry, I couldn't understand. I'm sorry, I couldn't understand the question. Will you? I'm sorry, I bother you. If you could repeat, madam.
Okay.
Sorry.
I repeat. Do the courts in Pakistan also recognize the decisions of foreign courts or arbitrations regarding cross-border Sharia economic disputes? And if yes, what are the terms or procedures for foreign courts or arbitration awards in Pakistan? Because we know that there is a relationship economics between two countries, not only one country. When they have disputes, sometimes they use arbitration in other countries, but it cannot be implemented in their countries because there is a contrary principle about Sharia and national law.
The answer is very clear. The Pakistani courts, they do recognize this arbitration, because this arbitration, international arbitration, is recognized everywhere, in where there is a no law or there is a conflict of laws, and a specific court in its jurisdiction cannot decide. In that case, you have to go to arbitration. And that is why Pakistan is paying many penalties as a result of arbitration. The government has accepted those decisions. So arbitration is well recognized principle in Pakistan.
How about if there is a difference in scholarship? Because we know that sometimes every country have their own mazhab, their own difference in scholars. Like Indonesia is Shafi'i, Maliki. Perhaps in some countries use Hanafi. Sometimes there is differences. How about to overcome, to solve about this?
Actually, I think that now this issue is no longer very much relevant or significant. The reason being that the AOFI, after the issuance of AOFI's Sharia standards, we are moving towards uniformity, towards standardization of these practices. That's why you will find that even Indonesia and Malaysia, now they have given up the Beolina or the buyback agreement, buyback, because they are, the reason being that AOFI has prohibited it. In the same way, Beo then sell of debt again. So I'm saying that gradually, what I have, what I have observed, that the strict position, the strict school position or madhab, every country is giving up the strict inclination towards affiliation towards his school for the sake of a universal standardized Islamic finance. And you are also surrendering many things. We are also surrendering. But I think that this process of surrender in Pakistan is slower than the process in Indonesia and Malaysia.
Okay, thank you very much.
So we are still hard, and we are not ready to give up our positions.
Last question from Shahzad Ahmed.
Assalamu alaikum. First of all, to all the participants, and my question to Mr. Tahir Monsoori and Mr. Muhammad Ayub. I am also basically from Pakistan, but I'm living in Turkey nowadays. So previously I have two different banks of Islamic banks in Pakistan. So there was, my question is, like as Dr. Tahir Monsoori said, the currently practicing in Pakistan, this is not a kind of Islamic banking or something like this. So, which is, in my point of view, I am not agreeing with Tahir Monsoori Saab. Basically, I have already worked with two different Islamic banks, and I have seen many clear pictures in the Islamic banks. So, what my question is, if it is not Islamic banking, then what is the actual Islamic banking figure? In short, like I want to ask in a short, because they don't have much time. And secondly, as you are saying that in the running musharaka, they are giving gift to the corporate sector. Yeah, of course, they are giving gift to the corporate sector, definitely. But why they are giving to the gift to the corporate sector? Because they want to create their market. Because as you know, there's a Islamic banking have a limited market nowadays in Pakistan, and with 30%, if they will not compensate, if they will not compensate with their desired rate or something like this, so definitely the customer of this Islamic bank will goes to the conventional bank, definitely. Like, so my there's I have a question, like in short brief, if you can please explain what is actually the Islamic bank should do so it can be Islamic bank.
I mean, the question is very broad. It is not really related
Monsoori sahab, aap jawab de rahe hain?
issue. So
I will take only 2 minutes.
Just,
only
yeah,
2 minutes. I have said that benchmark should be, for the time being, benchmark should be AOF's Sharia standards. If this is the case, then currency salam, which is being practiced by some leading banks, this is un-Islamic. Because Islamic Fiqh Academy International, they call it like gold and silver. So the rules will apply. So this is a violation. So far as this running Musharaka is concerned, this is again against the standard on Mudarba. The standard on Mudarba says that the bank has no right to surrender the profit, which is basically the right of depositor, and give it as a hiba to any person. This is a second violation. My opinion is that in Pakistan, the violation exceeds 30%, violation of AOF's and Sharia standards. And there are some other instances as well, which I can talk about it to my learned brother who has raised this, because this is not the time. And I will tell him, because I'm inside the industry, so I know that what is happening. This is not the time. So inshallah, I mean, we will be in touch, and I may tell him that what does Islamic banking mean and what does non-Islamic riba-free banking mean.
Yeah, if you share your email address, and Professor Ayub as well, maybe if they want to ask like some question, they can.
Inshallah.
Yeah.
Inshallah.
Okay, Professor Ayub, do you have anything like last words? Because I will close the session. Ustad Jarhi, yeah, I mean, it is late. Okay, go ahead. 1 second. Arkadaşlar, could you open Professor Jarhi's micro? Okay.
Okay. Well, thank you, Mr. Chairman. I just want to point out that when I was teaching Islamic economics in Qatar, I had a very good Indonesian student. I don't want to mention his name because I don't want to do some free publicity for him, but he deserves it. He asked me, you have taught us so much about the benefits of Islamic finance. How come Islamic banks do not apply it? So from this particular question, there came an article that you will find on Google that I wrote about the economic theory of Islamic finance regulation. Islamic finance, because of Sharia boards, tends to converge to conventional finance. I really would like to attract the attention of everybody here to my article on Islamic finance at Crossroads. There are many serious governance issues with Islamic finance. However, going back to what I have proposed, that we must take the macroeconomic approach, give the central bank a model to apply and also to issue the necessary laws to bring it to application, and at the same time tell them, solve your governance problems. One of the problems emanate from Sharia boards. Of course, I appreciate what Professor Monsoori has mentioned about that. We have Sharia board who is a member in about 100 boards all over the world, and he signs empty or blank pages and give it to them to write the resolutions, because they cannot possibly or humanly attend the meeting. We have so many problems. In addition, a Sharia board, a Sharia scholar cannot judge the economic consequences of contracts and actions. This is the job of an economist. The malat, you make a judgment, a Sharia judgment, based on mal or consequence. They are not expert in that. The majority of Sharia board members should be Islamic economists and should not be Sharia scholars. But this is only a small problem, small point that can be. There are many other points in that article, and of course, one of them is giving the responsibility of proof or putting them on the shoulder of the mudarib, not of Rabb al-Mal, in case of mudaraba and so on. And so we have to solve these problems, but I think we should leave them to the central bank. If we want to apply Islamic economics, do not think Islamic finance. This is, I repeat that, if you want to apply Islamic economics, stop thinking Islamic finance. Think Islamic economics. Think of a monetary and financial economic, macroeconomic model. Thank you, Mr. Chairman, for your patience.
Okay, thank you. Okay.
Prof. Kabir Hassan wanted to say something.
Yes, he raised his hands, Professor Kabir Hassan. Please go ahead and keep it short, because it is, it is early morning in your place, but
I know. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. I see so many familiar faces and my intellectual gurus on the screen, so I could not resist my temptation. This not really anything deep into this because it's too late. What I am really concerned that 1980s Riba judgment, it took another 22 years to get another judgment. And what I gather from the presentation of the two scholars and Professor Mabid al-Zarhi, that there is a serious problem with this judgment itself too. Now they're looking more at the form rather than the substance. There are so many other experiments in the world like Indonesia, Malaysia, like looking at the Islamic economy in a holistic way rather than looking at just a form, like as Mabid al-Zarhi mentioned, that Islamic finance is part of Islamic economy. And there has been a procedural issue that Professor Mabid mentioned, that Islamic monetary system, how to reform it. And there are some guidelines. And he mentioned also that he was there in the earlier verdict, the deliberation. So what I'm curious, I know the Pakistan supplies, huge number of Sharia scholars to the Islamic finance industry in the world. When this verdict was in the making, like, Supreme Court or the federal judge level, I'm sure they are very erudite scholars. While they have the consultation method, how come they did not approach directly to the people who work in this area, or they must have some sort of working group behind the scene to help them, like any Supreme Court. This is the highest court in the country. Now, from the presentation, what I see, then there will be review petition, there will be, and the judgment, and this spiral will continue another 20 years. So how do we summarize Islamic Pakistan economy? Why can't ultimately, it's the political will that is more important. and why this political will is not coming. Right now, there is a change in government, and what this government is going to do. Why Pakistan cannot stand on its own 2 feet rather than looking at what others are telling them to do. Sorry, this is all I want to say. It's very midnight, nothing deep, just my fear and my concern that whether we are starting the drama again in 22 years and then to run another 22 years and thing will continue. Thank you very much.
Okay, thank you. Professor Monsoori and Ayub, like just 1 minute before conclusion. If you want to say something, say something. Okay, I think there's nothing to say. So, I mean...
no, I think that...
yeah, please go ahead. Okay. I think, as I mentioned, we need more like programs and discussion about this issue, because the judgment is very important and crucial. It will be remembered in
no, you want me to
Islamic economics as a like landmark of intellectual integrity and also like piece of unmatched scholarship. I mean, it is important or unique document in the sense that it combines evidence from primary sources, history of Muslim people. If you read the verdict, it is a very important, document bringing like evidence from sources, from like economists, from the history of Muslim people, juristic text, opinions of contemporary renowned scholars and economists, all at one place. So that's why it's very important text, even to use in some like law schools and economic faculties as well. So that's why it is important contribution to the contemporary Islamic economic scholarship. Yes, as I mentioned, we are running out of time. So I would like to take this opportunity to thank you on behalf of the IKAM and whole group for the inspiring talk you gave to us today. Again, good afternoon and good night to all audience. Hope to meet you all again in other occasion.
And thank you, Professor Najmuddin, for inviting us.
Thank you. Thank you. It's my pleasure.
Thank you, Prophet.
Thank you.
Thank you, Allah.